Afternoon, sir. Ride program. What do you have to bring today?
The breathalyzer is the gold standard of testing a driver's blood alcohol level, and it's seen as infallible evidence in court. Now, a former government scientist's testimony in a DUI case could have a serious impact on the way police determine drunk driving. Here to discuss the significance of this is CTV's News legal analyst Ed Prutschi. And Ed, want to first touch on this fact that it was a former government scientist that said, hey, this system that we've been using is not infallible.
Yeah, and I think that's an important distinction because as long as there have been breathalyzers, there have been defense lawyers like myself challenging the breathalyzer and saying, hey, you ought not to convict a client based on a machine. And we've lost those kinds of cases over and over and over again, or at least that argument. The breathalyzer has been found to be a reliable and competent instrument time and time again. We've used what was the old Intoxilyzer 5000. Now in Canada, the vast majority of police forces are using this Intoxilyzer 5000C. But you've got somebody, former worker from the Center of Forensic Sciences. He was there for 13 years, and he says that there's a key measurement, a key calculation that the Center of Forensic Sciences has never done on this instrument, and as a result, the numbers that it gives out, the results that it gives out are not reliable, and the key issue is he got a judge to agree with him.
And that's huge. And so what does that mean now moving forward for those that have been convicted using this breathalyzer?
Well, so the most important thing it means right now is that we're headed to an appeal. Undoubtedly, the Crown has already filed an appeal, so we're going to have to see what the appeal court says about that, and probably multi-levels of appeal. But for those people who have already been convicted in the past, it's probably cold comfort because the ability for you to reopen your case after the fact is virtually nil. I don't think it's going to have any impact on people in the past. It may well have impact on people currently facing what are called over 80 charges that require this kind of breath instrument to give evidence. And it certainly has the potential to impact people who are going to be charged, as thousands of Canadians are every year in the coming weeks and months.
And this is the only system in place. This is what's used. There aren't alternatives in use right now.
That's basically correct. I mean, we've used an older model called the Intoxilyzer 5000C for many, many years.
But still the same company.
It's been upgraded over the last little while to the 8000. That's pretty much what everybody across North America uses. There is, of course, a blood test available, but as you can imagine, if you're at your ride spot check, nobody wants to see nurses standing by in a tent drawing blood from every person who's pulled over for an impaired driving case. The breath test system has really become the gold standard, the only standard.
So let me put this scenario before you. You're out driving, you're stopped. Are you in a position now to refuse a test and say, listen, they're faulty. This is now before the courts. You can't make me do this? Yeah,
bad idea, because the criminal code creates a separate offense for refusing to provide a breath sample. There's no doubt the law has not changed, so the criminal code remains the same. The question is this machine reliable, and will your lawyer be able to establish some unreliability there at trial? But if you say, no, I'm not giving a breath sample, you're almost certainly going to be convicted of refuse. Carries all the same penalties as if you had blown into that same breathalyzer, been shown to be above the legal limit, and convicted of impaired driving or over 80 instead. So the best advice I can give people: you're pulled over, you're asked to blow, you provide the test, then go find yourself a lawyer who specializes in these impaired driving cases, and they will look into whether or not this particular case or others, there's always other issues as well, are going to have impact on the ability of the Crown to get a conviction.
So many different ramifications here, tentacles all over the place on this one. We're not hearing a lot from the company that produces this.
No, they've kept their mouths very, very shut, and I think if they were to open it, they would be telling us, look, this is about how the Center of Forensic Sciences in Canada analyzes our results. We've got a policy manual. We tell them how to maintain it. We tell them how to calibrate it. It is an accurate instrument if they manage it properly. But they don't want to open their mouths because, of course, the last thing they want to do is risk the relationship they have with police forces all across this country, where they sell hundreds of these units every year.
And maintenance was a key. That was something that was brought up. You know, were they being maintained properly?
Yeah, these machines, it's not just like a computer that you plug in and leave it. I mean, it does have parts that wear out. It does have calibration testing that needs to be done for each and every test, as well as weekly, monthly, and annual maintenance cycles. And so it's been a battle all the time for us defense lawyers. We ask for that kind of maintenance and calibration data because we want to be able to ensure that it's actually been done and done properly. Interestingly, even before this case, the Court of Appeal has come back and told us, hey, you're not entitled to that. Basically, the machine works, just trust it. That's the worst thing you can ever say to a defense lawyer. We don't trust anything.
All right. Well, the Crown has filed an appeal. We'll have to see how this plays out. Ed, thank you so much.
You're welcome.